Morning. Good morning. Please be seated. Please call the case.
Yes, good morning, Your Honors. The matter before the court is the case entitled Stowe Aviation LLC et al. Against Agency of Commerce and Community Development, case number 23AP311. Representing the appellant, Stowe Aviation, is attorney Michael B. Stevens. Representing the appellee, Agency of Commerce, is attorney David R. Groff.
Thanks very much, and good morning, counsel. We'll hear from counsel for the appellant first, of course. Please come on up to the podium. And for the record, introduce yourself if you would, and identify your client, and then proceed. But if you throw your papers at us, it's going to count against you. That's all.
Good way to start. Good morning, Your Honors. Michael Stevens on behalf of the appellants, Stowe Aviation LLC.
Thank
and Stowe.
I'm just making a joke.
I understand
that.
I understand and I appreciate that. Your Honors, I'm going to go ahead and lead off with my second point first from my brief, which is that the trial court committed error by not allowing us to amend the one and done order of dismissal with prejudice under either Rule 59E or.
Can I interrupt you there? Once the court dismisses, what's there to amend?
What's that?
Once the court dismisses, what is there to amend?
Well, we wanted them to dismiss their order of, amend the order of dismissal. The order of dismissal that was entered by Judge Teachout did not provide any leave to amend if we so wanted to do that. And so that's what we were seeking under Rule 59 and Rule 60 after the motion to dismiss was granted and leave was not afforded to us to correct a pleading deficiency that was cited by Judge Teachout. That's what we're seeking to have.
Okay, so I thought that's what you were appealing was that you weren't able to amend the complaint.
That is correct. That is correct. But the rules don't allow us to seek leave to amend that order because it was final. And so what we wanted to do is we wanted to seek leave to have her correct the final judgment, the order of dismissal with prejudice. That's what we sought to leave under 59 and 60. And those two rules allow post-judgment relief. And this court's actually been faced with that before. And the first case I kind of want to talk about, talking about that, is dealing with this Vermont tradition of liberal amendments to pleadings. And the reason why we do that is
when the case is pending.
When the case is pending.
They all have to do with cases where the case is still pending.
Well, yes, but there's also no case law that says that tradition needs to only apply to a Rule 15 motion for leave to amend. The idea is we want to serve the ends of justice. We want parties to be able to have their day in court and to not be forced out by a technicality, be able to have an amendment. And that's kind of where that comes from. And to be honest with you, that issue was before this court about 48 years ago. And the state of Vermont was standing where I'm standing right now. The shoe was on the other foot. And they came before you all. This was in the state of Vermont versus the Equinox House. And they went ahead and they had their case against an individual dismissed with prejudice, no right to amend. The state of Vermont was under far less solid footing than we are on right now. They didn't ask for leave to amend at the trial level. They didn't file any post-judgment relief under 59 or 60, asking for relief there. They instead waited, came before this court, and for the very first time asked for an opportunity to go back and amend and correct the complaints. That way they could go ahead and state a cause of action. And the court at that time went on to state that that was a very risky move on their part. That because they did not actually ask for relief under 59 or 60 and waiting to ask for the first time when they got here for that relief, that was a very risky move. But this court found that the ends of justice would be best served by allowing them to amend their complaint in that case.
So how do you jive that ruling, which I understand, and MITEC?
And
the MITEC.
Well, so in my take, yeah, it's interesting because both the trial court and the appellee both rely heavily on them. And if you take a look at that, the plaintiff in that case actually had the merits of their case decided. If you take that wasn't a one and done dismissal of the motion to dismiss stage. That was a case, I believe, a coverage case that got all the way through to the point I couldn't tell if it was a verdict or a summary judgment. It was probably summary judgment since it was coverage. But at that point, the plaintiff actually had their day in court. And then what happened was the plaintiff realized after they won, they forgot to add account for costs. They forgot to add account for costs. And so they said, hey, we'd like to go ahead and seek leave under 59 and 60 to amend a complaint to add a claim for costs. And again, completely distinguishable here because we're one and done at the motion to dismiss stage. In our case in particular, we actually only had our complaint looked at by the trial court one time.
Have you got a case that says Rule 15 survives a dismissal?
I do not. I do not have a case that says Rule 15 survives the dismissal. And so that's why I'm pushing on my point first on the 59 and 60 to kind of start right now. But Your Honor, going back to the Equinox case, this court said that was not the safe route that they took. And then this court provided the safe route. And this court said that this court, if the court does not provide leave to amend, the safe course is to move for leave within 10 days. It was 10 days then, it's longer now. Permitted by Rule 59E for a motion to alter or amend a judgment. It would appear that at the latest, leave to amend must be sought within the year permitted by Rule 60B for motion for relief from judgment. This was the guidance given by this court for a party in my client's position where they were not able to amend their complaint, and what the safe course of action should be to be able to go ahead and amend their pleading. That's what we did. We followed this guidance on it. If the state is able to come before you all and seek relief under less favorable circumstances, surely my client should be able to seek that relief when we have followed the rules kind of given by this court.
Rule 60 requires a finding of extraordinary circumstances in this posture. Would you agree with that?
I would agree that the language of it requires there to be a just reason for it. And so, yes.
And wasn't there not extraordinary circumstances for your failure to request an amendment, motion for an amendment to the complaint prior to dismissal of it?
Well,
was that a tactical decision? What was that?
I know that's how it's phrased in the appellee's brief. And no, it was not a tactical decision. I would submit to this court that I practice in a lot of jurisdictions, and judges routinely look to give litigants the opportunity to correct a procedural issue with their complaint. And leave is almost, in my experience, always given when it's a technical issue. Now, if there's a ruling that it's a futility issue, that there's no basis to make the amendment, we're not going to waste the court's time and be judicially efficient, then fine. We're not going to give leave to amend. But even, yes, sir.
I'm sorry. One thing I take issue with is, and this falls under the 60B for consideration, is you say in your brief that the court found that every one of your claims was a valid claim. And the court, as I read it, didn't do that. The court found that really the only potential valid claim was of the transfer of the MOU to the Department of Financial Regulation. The others, Judge Teachout did address and say that there's no promise by the state of Vermont to supervise the EB-5 issues in order to have the MOU in this case be properly addressed. Can you address that? Because I don't think you're correct when you say that the court found that every single claim had merit.
In Justice Caroline, I recognize that this is not all of your first go at EB-5 litigation with this stuff too. And yes, absolutely. And if we take a look at her order, and I don't recall that my briefing said that she agreed with all of our counts. I believe the position we took was, and I'm on page 4 of her order right here, and I quote, "The court finds that Stowe Aviation alleges a breach for a basis for a breach of contract claim," and then she cites about 6 paragraphs with regard to not 1, not 2, not 3 actually, and that's ACCD's and VRC's unauthorized and unilateral transfer of the MOU to the DFR. 2, DFR's action in making additional demands on Stowe Aviation. And 3, the Vermont Regional Center's cancellation of the MOU. Those are the 3 points that I intended to alert the court to, that the court found that served as a basis for the breach of contract claim. That the court made a finding in her order. That's what it says, the court finds.
Oh, I read that as her finding that you made those arguments.
Okay, well, I read that the court find those points, and that
Fair.
Because then she jumps into, nevertheless, the damages are not causally connected. You haven't pled that out. Okay, you haven't pled that properly, even though we did have a plain statement of damages, which is all that technically is required under notice pleadings, but nevertheless.
Thank you.
All right, but the second issue that we raised in our complaint on the cause of action was the implied covenant of good faith and fair dealing. And the implied covenant of good faith and fair dealing has really no tie to a breach of an express term of the agreement in itself. And so while I understand that we're here today under the idea that traditional fairness of amending this complaint to get things right, that's really the basis. We're not digging super deep into the order. She didn't find futility in her order denying the motion for post-judgment relief. The second amendment complaint that she had us file as part of our briefing, which we did, there's no reference in her order as to a finding on that. She asked us to do it, and then her order denying her post-judgment relief is completely silent to it.
So, Counsel, there's a good bit of briefing here. I'll ask your brother as well, but was this issue about the failure to allege damages stemming from the transfer, was that actually a subject of briefing and argumentation of the state?
With respect to the motion to dismiss?
Right. The ground that was relied upon by the court, was that something that was in play in the briefing?
As I say here right now, I can't recall if that was briefed specifically by the state in the briefing on it. But what I would like to point the court's attention to is this idea of fairness and having a situation where you have a one and done with prejudice, with the court only taking a look at a pleading one time and the appellant or the party not having an opportunity to correct it. It's happened before, just not in the state of Vermont. And the cases that are cited by the state, the two of them are just so egregious in their context. Clearly, the result was appropriate. I mean, the first one that was cited by the state was the April Gallup versus the Vice President Dick Cheney Donna Rumsfeld case, where somebody was injured in the Pentagon on 9/11, and she sued everybody in the government, claiming that it wasn't an airplane that crashed in the Pentagon, that actually the United States set charges and explosives in there, and therefore her injury should be remedied by the United States. The court then said one and done with prejudice. We're okay with considering some fringe theories, but if you don't come here with facts that support it, we're not going to let you get past the first motion to dismiss. The other case they reference is the Horisoko versus Citibank case, another Second Circuit case where you had people that were trying to delay having to get out of their house in foreclosure. They hadn't paid their mortgage. And they went ahead and sued their lender for RICO violations at that point. The court said one without prejudice. That's not what you have here. You have an actual litigant where the United States has actually found failures in the state to comply with an EB-5 charter that we've alleged damage to. My clients haven't had their day in court to actually look at this. And all we're asking for is that opportunity to be consistent with Vermont's tradition of liberally allowing these amendments, which there's no case law says it has to be, that end has to be fulfilled through a Rule 15 motion for leave to amend. With respect to the second point, the first point that we raised, Your Honor, we'll go ahead and rely on our brief for that point to the extent that the court, if you have any questions on the argument thus far, if not, I'll reserve the remainder from there.
Okay, thank you very much. We'll hear from we have Colleen now. Counsel, please come on up and introduce yourself and identify your client.
Thank you, Chief Justice Reiber. My name is David Groff. I'm Assistant Attorney General. I'm here for the Agency of Commerce and Community Development.
Thank you.
There are two issues that are properly before the court today. One is whether the trial court was required to sua sponte, relieve the plaintiffs of their tactical decision not to seek leave to amend and to grant an unasked for leave to amend when there was no request for that. Secondly, the question is whether post-judgment, the plaintiffs were entitled to amend their complaint under either Rules 15, 59, or 60. The answer to both of those questions is clearly no. As to the first issue, there is nothing in civil rules or any case law that says when deciding a case on a substantive basis on a motion to dismiss, that a court is required to grant an unasked for leave to amend. In fact, if anything, Rule 41B3 suggests the opposite. Under Rule 41B3, when the court dismisses a case, unless it's for some grounds that aren't applicable here, like jurisdiction or venue, a dismissal is presumed to be on the merits. unless the court specifically says otherwise in its motion. So,
Can I jump in? Can I ask you to answer the question that I asked, which is essentially some of the cases that you've cited focused on the fact that, where the person hasn't asked for leave to amend, they can be saddled with that tactical decision. I'm wondering whether the defendant plaintiff here was on notice of this particular issue that was relied upon by the trial court and specifically chose not to ask for leave to amend. It seems like the trial court in its termination that there was no allegation of damages. I didn't see that in the briefing, but if it is in the briefing, please let me know where it is. And if it's not, how do you jive those two things?
well, I think you're right. It wasn't raised in the briefing. And I think that's a tactical choice that the plaintiffs made. The state moved to dismiss this case saying, you have no rights related to, you have no contract right or no right under the covenant of good faith in dealing to have the state supervise JPEAK in any particular way or otherwise with respect to this contract. And the plaintiffs didn't respond to that and say, oh, wait, but we have a right related to your assignment of this to DFR. That was their choice. Their choice was to argue instead, no, we do have a right related to JPEAK. That was the tactical decision that they made. And they also made a decision to meet that on the merits in the briefing without asking for leave to amend. When, and I think this highlights that it was a tactical decision. This was the second time the state moved to dismiss this case. The first time the state moved to dismiss the case, plaintiffs did seek leave to amend and did amend their complaint. So it's not something that was outside the realm of possibility. They made a choice to confront the state's arguments head on. And we think that the court was under no obligation to relieve them of that choice. Now, we couldn't find a case from this court specifically saying that dismissal need not be without prejudice at this stage, but MITEC certainly suggests that, because the issue in MITEC was whether or not post-judgment Rule 15 applied. This also goes to the second point, or whether it's governed by Rules 59 and Rule 60. Now, if there was some underlying requirement that whenever the court granted a dismissal, it had to do it without prejudice, then that issue should have been addressed in MITEC. But instead, the court assumed when deciding MITEC that it's perfectly normal to dismiss a case with prejudice without granting leave to amend. So,
But Mr. Brown, there are avenues of relief available under Rule 59 and Rule 60 to those types of situations where there's a mistake or there's inadvertence, neglect, or in the interest of justice. So those two rules do give an out, potentially.
they absolutely give a potential out. I was just moving to that point, Your Honor. Those are the means for a potential out in this situation.
And not Rule 15.
Absolutely not Rule 15. That's squarely decided by MITEC. Counsel's reliance on the Equinox case from 50 years ago, to the extent he's suggesting otherwise, is abrogated by MITEC. That was the holding of MITEC. 59, 60 are the way out of this situation. But
The council in MITEC, they also relied upon, the basis for MITEC was a Seventh Circuit case, which also said that you're supposed to look to the merits of the motion to amend, didn't it?
yes, but it's governed under the Rule 59 and Rule 60 standard, not the liberal pleading standard of Rule 15. And so
So the process would be relief from judgment first.
right.
Get a relief from judgment either on 59 or 60, then file a motion to amend, throwing in additional information regarding damages, for example, in this case.
Well, I think the plaintiffs eventually invoked it correctly, and that the way to do it would be relief under Rule 59 and 60 with the relief requested being an amendment to the complaint. And I think that's eventually where they ended up. I don't think they came anywhere close to meeting the standards under Rule 59 and Rule 60. But I think process-wise, they eventually got to the right place.
And they're different. I mean, there's a different standard between the 59 and the 60 determination, are there not?
They're similar. Rule 59 sets out certain specific avenues for relief, or Rule 60 does, that I don't think they even allege. So inadvertence, mistake, those kinds of things. They're, with respect to Rule 60, relying on the catch-all, 60b-6.
Interest of justice.
Interest of justice. And that part of Rule 60 does kind of end up sounding a lot like the Rule 59E test, which is an extraordinary remedy. Rule 59E also allows for corrections of mistakes made by the court, but there was no mistake made by the court here. They just disagree with the court's judgment. And so we think that the plaintiffs didn't show anything approaching extraordinary circumstances justifying relief under Rule 59 or 60. In fact, this is a pretty common circumstance of a motion to dismiss being granted. And the plaintiffs seeking relief from a substantive decision a tactical decision that they made. I want to.
Can I ask you, what is the benefit of the tactical decision that you say they made? What are they getting out of making that tactical decision?
Forcing a judgment on the substantive issue of whether or not they had rights related to state supervision of JP. That's the basis of, that was without a doubt the thrust of their complaint, the primary basis of their complaint. And counsel mentioned the proposed second amended complaint, which did nothing other than double down on that theory. If anything, the proposed second amended complaint relied more heavily on the supposed duty to supervise JP. I mean, that had clips from depositions in the JP cases and cites to memos from the JP situation. So I think it's fair for the trial court to have assumed that the plaintiffs wanted a judgment on the basis of that claim, and they should be held to that choice. Counsel didn't address it here, but I do want to address the first point that he did not address today that is addressed in their brief, which is an argument that substantively the trial court got it wrong. With all due respect, that argument is not before this court. The plaintiffs, number one, never alleged, as Judge Tomasi asked me at the outset, in the beginning of, in opposition to the state's motion to dismiss, they never alleged, oh, we stated a claim with respect to DFR. Secondly, in none of their post-judgment motions did they say, oh, trial court, you got it wrong. Substantively, you shouldn't have dismissed our case. They never said that. What they said was, give us a chance to fix our complaints, to correct the errors that you recognize for it. So they can't come to this court and say the trial court was incorrect in dismissing the case. All that they can ask for is leave to amend. And for that relief, they're under Rule 5960, and we think clearly did not meet those standards. Unless there's any other questions.
Okay, thank you very much.
That's it.
How much time does the appellant have, please?
Your Honor, appellant has 2 minutes and 50 seconds remaining.
Thank you, counsel.
Your Honors, Justice Eaton's point is well taken in that what would have been the tactical decision for wanting the judgment at that time and not an opportunity to cure a technical deficiency in a complaint the first time the judge had an opportunity to take a look at this. There is no reasonable assumption that could be made as to why anybody would want to just say, we're going to just not want that opportunity to fix it. My clients clearly have alleged that they've been injured by this. This is a significant case for them. And to say that any party goes in and rolls the dice like that, I'm just going to go ahead and be one and done voluntarily is not fair. That is not.
So, Mr. Stevens, I mean, interrupt you mid-sentence.
Yeah.
So what I don't understand is that this issue was raised, it comes up in the initial motion to dismiss on the first complaint, and it's flagged. And there was no effort or actions regarding trying to cure that at that point while the case was still live, where you could have filed a motion to amend or request for a motion to amend while the case was still alive.
Are you talking about the initial complaint
The initial complaint.
that we agreed to amend voluntarily after the motion to dismiss?
Well, that there was an information that's contained in the motion to dismiss that there was insufficient evidence regarding any claim for damages.
Right.
And that there was no response on your part, on your client's part, to cure that when it's being flagged as part of that initial. Is that a clear question? Maybe it's not.
It is. But what I would say, Your Honor, is that the amended complaint that we voluntarily agreed to do did expound upon the damages. It wasn't that there was no damages alleged in either of the complaints, but the issues they took issue with in their first motion to dismiss, we thought we corrected. And we did make that effort to correct, not just with the damages, but with the factual issues that they took issue with to kind of narrow this down. And again, we chose to do that because we're trying to be efficient. We're trying to move this along. The trial judge never had an opportunity to weigh in on that issue. And then we thought we were good. And when they filed another motion to dismiss for our first amended complaint, we addressed it again that we had resolved this. Judge Teachow disagreed. And that was her order on her motion to dismiss. Again, it was not a tactical issue to not seek leave. It simply was a matter of we believe we had corrected it, and judges do typically go ahead and give leave to amend for that.
And that would have been a merits appeal. That would have been an appeal on the merits at that point.
Yes, it would have. Yes, it would have. And instead, we're here today asking for relief under 59 and 60 under what is, again, the traditions and just for allowing a litigant to have their day in court.
And you don't dispute that's that motion is the sole issue cited in your notice of appeal.
That is our second point. Yes, that is the motion. Yes, that is the motion that is sought where we are seeking a relief from that post-judgment motion. And I would just point out that lastly, that the Equinox case, was not rebutted in their brief. It was just referenced a moment ago by counsel. But again, we'd ask the court to reverse the decision and allow our clients to have an opportunity to have their day in court. Thank you.
Thank you very much. Please call a conclusion of the hearing.
Yes, Your Honor, that concludes today's hearings.
Thank you.